So I would also like to welcome and thank Mr. Nishant Sharma, Lead Counsel IP Litigation, Dolby Technologies, for having given his consent to be the expert instructor for today's webinar. Thank you so much. So intellectual property is going to play a very major important role in the bringing up the economy of the nation in the coming times. So today, corporations and firms are looking forward to hiring the individuals who are IP literate. So it is therefore, and it's important for you, especially as a student, to have an awareness and knowledge of intellectual property as you start shaping your careers. So intellectual property talent search examination, IPTSE, aims at helping you take the first step towards creating an IP mindset. IPTSE is working very aggressively to create the IP awareness across India, and we are having a vision and mission to touch base 10 million students, which include the working professionals, startups, and the faculty members by digitally and physically by 2025 to promote the IP. So this initiative was launched in 2018, and since then, we have already completed 4 editions of this IP Olympiad. The same has been successfully completed, which were also supported by government bodies like AICTE, NRDC, METI, Department of Science and Technology, Punjab State Council for Science and Technology, IHF, etc. So it identifies a young talent through an annual exam that is taken online, covering various questions on several aspects of IPRs, including patents, designs, trademarks, copyright, geographic indication, and trade secret. So I'm happy to announce that we have also launched the 5th edition of IPTSE on 1st of September. Thanks to Ericsson for coming forward in supporting this initiative in enhancing the IP literacy in the country. We would also like to thank Creative Corp and Federation of Indian Chamber of Commerce for supporting us as a knowledge partner. So our team would take you through the details of the 5th edition and the registration process at the end of this webinar. I would like to mention here that IPTC Academy have already signed more than 25 MOUs with the education institutes. So thank you once again, and I'm sure you are all also going to get a lot of information and knowledge from this webinar. Thank you, everyone. Thank you once again.
Thank you, sir, for your inaugural and introductory words, which have set the tone for today's topic. Now I would request Mr. Azim Pathan to welcome the participants and our speakers.
Thank you. Very good morning to one and all. And for this very important session, as this very important area of IP and more specifically intellectual property rights, and indeed this patent industrial designing, that is one of the important gray area, one of the important indeed focal area for economic growth of any country. So in that context, and more specifically the countries which are growing with this IP on intellectual property and more specifically the patents, those countries are now presently on the top of the world. We have world intellectual property rights regimes, the index already in the public domain, which specifically says that now presently China and how exactly United States of America, and then more specifically Japan, they are topping in this entire domain of IP and more specifically patent filing. So in that particular scenario, we can also see the growth of this Indian economy as well. And obviously India is also contributing in almost 2021, the data which I was observing. So 40% all applications all over the world that was coming from India, and IP filing and more specifically patent filing, it was from Indian from Indian land, or we can say Indian continent, we can say. So obviously we are topping in the sense now the data which shows that in 2021 we are coming on the 35th rank, as compared to 2015-16, we were on 81 rank. So now we are also growing, or our economy is also growing. So one of the important focal area of growth of the economy, how much, intellectual property or how much, patent we are, having with us. So ultimately, based on that, the growth or the directions of any economy is dependent. So in that important perspective, obviously, the role of IP, role of patent filing, or more specifically, patent with any particular country, it becomes very, very vital for the growth of any country, or we can say for the growth of any particular system. So in that particular background, I find that, the workshops like, which provides the skill building for the students, for the academicians, for the professionals, that is very important. And the very important work of this, IPTHECON is, this is very important. IP, this one of the important, organizations, and, Mr. Saurabh and, all people, they are, working in this particular, the domain, that is very important for building the skill of the people so that they can grow in this particular area. And, consequently, ultimately, we can say and we can find that the growth, there is the growth, and there will be contribution from each and every one of us who are working in this particular area to contribute in the economy of the country. So from that perspective, School of Law, GD Goenka University, on behalf of GD Goenka University, on behalf of Honorable Vice Chancellor, Professor Dr. Tabrez Ahmed, I welcome to all participants. I welcome to all, head of the department who have joined here. I also welcome to, entire team of IPTHECON. I also welcome to all student participants and all, and I extend my heartfelt gratitude to them for joining this particular session. Besides that, let me also brief you that this IP, intellectual property, besides that, this artificial intelligence is also one of the important growing area, and lot of important, patent are, available, or patent filing specifications are available, where we are finding that lot of new innovation is possible. So in that particular, domain, School of Law is also offering, certain important new courses, new specializations, like, more specifically artificial intelligence and law, cyber law, and, technology, forensic science, and, technology. Like those courses, as a specialized courses, we are also offering, which is also catering the demand of, these law firms, these legal complex issues, resolving legal complex issues. So in that particular, perspective, I find that these kinds of, workshops will also provide, a new kind of, skill building for the students and, the professionals. So I once again thank you to all of you, and I welcome once again to all of you for joining this particular session.
Thank you so much, sir, for such a warm welcome and giving us all the insights of the IP. Moving forward, I would like to invite our speaker, Mr. Nishant Sharma. Mr. Nishant is responsible for advancing and propagating Dolby's patent licensing program in India and Southeast Asia. He also oversees the company's litigation strategy against implementers and acting and unwilling licensees. Being an electronic engineer and having a degree in law, he takes keen interest in reading about latest developments in technology area and also about the interplay of law and technology. Prior to joining Dolby, Mr. Nishant has worked with various law firms and has extensive experience in patent litigation, patent prosecution, and preparation in various domains, including inter alia electrical, electronics engineering, mechanical engineering, and biomedical engineering. He has represented his clients before the various high courts, appellate boards, and patent offices branches in India. Mr. Nishant is keen to spread IP awareness in India and has authored several articles relating to patent law and related to issues in IP journals. He would be enlightening our participants on the topic of the webinar and share with them the intriguing concepts related to patent drafting. Sir, please.
Thank you for this introduction. I hope I'm clear. My voice is clear. So, in case at any point of time you are unable to hear me, just let me know. The other thing is, I had requested that in case any one of you have any questions during the session, please feel free to raise that at that particular point of time, because maybe we might miss out on some important questions that if you keep it for the end. So I would just request the organizers that I won't be able to read the chat because I'll be just concentrating on the uh, uh, I'll be taking you through the presentation. So maybe I'll request the organizers to let me know in case there are some questions in the chat. Okay, so as you, sure. So it's an honor to be speaking before such an august audience. I am myself an engineer, and I know the enthusiasm amongst academicians and engineers to publish papers for their researches that they have carried out. Generally, I have what I have observed is researches. Some of the researches are like blockbuster technologies, and maybe if you publish a paper and bring it into the public domain, you probably lose the opportunity of commercializing it and maybe reaping out the benefits out of it in a very holistic manner. So that's where the importance of today's talk comes. What I'll be talking about today is an additional step. I'm not dissuading you from filing research papers, but what I am suggesting is maybe you should also consider filing a provisional application before you publish a paper and bring out your technological development or whatever research you have carried out in the public domain. Because once it is in the public domain without any protection, you may not get any monetary benefits or any protection per se on that particular technology. So that is where I'll be leading you to, maybe for your consideration. And as Azim sir talked about skill sharing session. So yes, I'll try and make you explain how to write a provisional specification, which is not something very different from how you write a research paper. It's almost on the same lines. As I said, it's only an additional step that you may have to carry out and just file it before you publish your research paper. So let me just try and share my screen. Right. So can you see my screen?
Yeah, it's visible.
Okay. Sorry. Right. So as I said, I'll be talking about drafting a provisional specification, and I'll be telling you about the best practices that you need to follow. Nothing very complex. Maybe in the simplest of terms, I'll try and explain to you how you can write a provisional patent specification. I think I'll have to share my screen again because I'm unable to move the slides. Okay. Right. So what I observed when I was practicing as a patent attorney with law firms is that we would face different type of questions coming in from researchers, and some of those would be that I have developed a new product and I I need to display it in some exhibition so as to maybe get people's response on how they are responding to that particular product before I make more investments and maybe take it on a commercial scale. Again, there is a new product that you may have developed and you are going to have a discussion with a potential investor. So that's another point that many innovators came to us with, that we are going to disclose this particular product, which is maybe not known to anyone as of now. It is a unique product, and we are going to discuss for investments with a potential investor. The other type of queries that we have received is somewhat coming in from academicians, wherein they have developed a new technological solution and they are planning to publish a research paper. Now, in all these cases, these are innovative blockbuster technologies, probably. You never know, it may turn out to be one. And the innovators as such are planning to bring that before the public by disclosing it in one way or the other, which, as I said, is not advisable, because if it comes into the public domain, anybody is free to use that without any benefits as such to the innovator or the researcher. So coming to why do we file a provisional patent application? So in all these scenarios, what was suggested to these different people was that they should first file a provisional patent specification before going for any public disclosure of their innovations or researches. So what is a provisional patent application? A provisional patent application gives you a preliminary, or I would say a provisional protection for the innovation. So in a way, it gives you a priority date, as we call it. So what you do by filing a provisional specification is, in a way, provisionally protect your innovation from that particular day when you file the provisional application. So in a way, what you get is a filing date, and from that particular date, that innovation is provisionally protected in your name. What that means is, if anyone else is going to file another patent application on the same innovation, or maybe is developing a product based on same innovation, then the protection is available to you. You can go ahead and stop that particular person from getting a patent on that particular technology, or once you have a patent on your technology, you can also stop that person from making or using your innovation. So this is what we mean by a protection. Obviously, the provisional patent application only gives you a priority date, as we call it, from where your protection would start. There are other steps after filing a provisional patent specification, and you get further protection, the robust protection, once you go through the entire steps of examination of the application, your patent application, and once a patent is granted. But your protection starts from the date when you filed the provisional application. So when is it advisable to file the provisional patent application? It is always advisable whenever you are going for an intended public disclosure, such as whatever I discussed, like you are going for a business discussion related to the invention with an innovator or with an investor, or you are planning to publish a paper in a research journal, or maybe you are launching a product in the market. So before taking any protection, you need to you cannot go ahead and launch a product in the market, because, as I said, it would go into the public domain and it won't be of any use to you. Anyone would be free to use your innovation at your cost. So these are some of the scenarios, and the other scenario is if you are going to display your product or prototype in an exhibition or a fair. So these are some of the scenarios. There may be other scenarios as well. Maybe you are discussing it in a closed group. Your innovation you are discussing with your closed group. That could also amount to public disclosure. There have been judicial decisions which say that even if you have disclosed it amongst a closed group who are in a way technically capable of understanding that, then also it could be considered as a public disclosure. So that could also be damaging to your research in the sense that it is no longer considered as protected. So these are some of the scenarios where you may have to consider filing a provisional application before going for any public disclosure. Right. So before we go into what is a provisional patent specification, or how do you draft it, I would just like to briefly tell you about what is a patent. Uh, we have had this discussion of protection being granted to you if you file a provisional patent specification. Finally, your innovation would be protected by a patent, which is a statutory grant given to you by the government so as to exploit your innovation in an exclusive manner for a period of 20 years. So what you do is you disclose your innovation to the government, and the government examines it and checks that this innovation is entitled to be granted a patent because it is innovative and it may benefit the society as such. It may lead to technological development. And so, based on all these criteria, evaluation of all these criteria, the government would grant you a patent. So now what a patent does is, as I said, it protects new innovations. Whatever new technology you have developed, it secures your right as innovators. How does it secure your right? It is a negative right. If you read through different patent literature, you'll find out that patent is termed as a negative right. Why so? Because a patent is a right that enables you to prevent someone else from using your technology or your protected innovation. So it prevents any unauthorized use. So if someone is using your innovation, you can go ahead and seek the protection of the court and use your rights to stop that particular person from using your innovation. So how do you earn from a patent? You are capable of licensing your patent to different parties who want to use your innovation maybe for commercial exploitation. So you would give a license to, suppose you have a product on maybe a new radio receiver, and you find that you are not in a position to maybe commercially exploit it because you don't have the ways and means to, in a way, make it a commercial product. But there are different other companies in the market who are producing radio products. And what you can do is you can approach those companies, tell them that you have a patent in your name on those particular technologies. And based on that, maybe after a discussion, if they are interested, they could take a license from you on that particular license to use that technology under the patent. And in return, they would provide you with some monetary benefits, maybe give you a royalty or maybe give you a lump sum figure, something like that. Uh, Patents also help in technological developments. So what happens is whenever a patent is granted, it is published in the public domain. So it is like a limited monopoly that is granted for 20 years to you. So you have the exclusive rights over that particular technology for 20 years. But what happens after 20 years is that the technology comes into public domain. So anyone who reads through that particular patent is uh, uh, entitled to, in a way, make his own research on top of your research and develop new products or new technologies. So this is why it is called a limited monopoly. And after 20 years, everything goes into the public domain. And when people start developing their own technologies based on your research and development, it leads to further technological developments. So other people might be filing uh, innovations, might be filing patents for innovations that they developed on top of your innovation. So it is like an ongoing process. Maybe once they get a patent, probably you might also work on whatever research and development they have done, they have shared in their patent. Maybe you'd get some more ideas and maybe file another few patents on by doing further research. So that's how a patent helps in technological development happening in this society. The other limitation, I would say, of a patent is that it is jurisdictional in nature. So if you have a patent right in India, it would give you rights of protection only in India. So if you feel that your patent has a market in US or in Europe, then you need to file separate patents for that particular technology in India, US, and Europe, so as to get a wider protection and maybe commercialize to be able to commercialize your innovation over a wider audience and get better commercial benefits out of it. So what is the basic criteria based on which a patent is granted? As I said, whenever you file a patent application, it is examined by the government, which is the patent office, is the representative of the government who examines your innovations and checks whether the innovation qualifies on basic three criteria, which is referred to as novelty, inventiveness, and industrial applicability. So these are the three basic tests. Apart from that, there are some other tests also. We won't be going into that because that's not within the scope of what we are going to discuss today. But I would say these are the three basic tests that are carried out. So the patent office checks that whether your innovation is novel, that this is unique, no one else has done the same research. And I think a test of novelty also happens in case you publish a research paper. They also check if whatever you have written is unique and is not already there in the public domain. The patent office also checks for inventiveness. So this is a very subjective criteria that is checked. So what they do is they evaluate your innovation to check whether it is a sort of development that we have done which is very obvious or which is a mere workshop improvement of what is already known. So maybe you made a pen with an ink container, and then probably you removed the ink container and your innovation provided a cartridge, an ink cartridge, instead of the pump and tank that is there in a fountain pen. You replaced it with an ink cartridge. So this might be, and this is just an example, so not a hard and fast rule. I'm just trying to explain what could be an obvious change. So in the patent office might feel that this change from removing a tank to already filled, a pre-filled cartridge could be considered as an obvious change or a mere workshop improvement. So you didn't have to apply much of your mind and you just arrived at a replacement of the existing technology by a very small change. So that may be considered as a very obvious change, and the innovation may fall on the criteria of inventiveness. The other thing is industrial applicability. So this is a very important aspect in the sense that it deals with abstract type of innovations. It requires that your innovations should be such which are capable of being manufactured in the industry or maybe capable of being used in the industry. It should not be something like an abstract idea which you are trying to, in a way, claim. So maybe an idea for something like rigging bets. So maybe this is like an abstract idea. If you just made an innovation or a concept or maybe an algorithm wherein you place in some parameters and then give an output wherein you advise the person as to what bet he should be placing. So it's a very I would say a very vague example, but what I intended to say was all these are sort of mental acts or maybe something like which is not tangible in a tangible form. So all such innovations may not be considered as patentable and may be denied a patent on, because what is considered as things like that need to remain in the public domain and no one can claim protection over such abstract rules or abstract ideas. Right. So what I've done is I've just tried to compare a provisional patent application versus a research paper. As I said, I'm not dissuading anyone from filing research papers. Please do file those. Those research papers are also very important. They help in technological development, as does a patent application. But there are some drawbacks in the research paper publication if you do it prior to filing a provisional application. So as I said, a research paper is published and is open for public to review. So there's no as such protection available to you. A provisional application, on the other hand, is not made public and it is not open for review by the public as such. So In the process, what you do is you file a provisional application, and within a 12-month period, you have to file a complete specification. So that is when your innovation starts coming into the public domain. So unless and until you have gone to the step of complete specification filing, your innovation, when disclosed in a provisional application, would not be made public. So you won't be able to anyone would be able to, in a way, review your innovation, whatever you have filed in the provisional application. And why that is done? Because, as I said, it is only a provisional protection that is given to you. You are just protecting it with the statutory authorities, the patent office, so that in case in future any claim comes that who made this innovation first, so you can always claim that I filed a provisional application and this is when my innovation was protected from. Again, the primary purpose of the research paper is to aid dissemination of information. You are sharing it with the public. The primary purpose of a provisional application is to protect the innovation on a provisional basis. And I said, you secure the priority date in your name, in the sense that you are getting a priority date for your innovation, that you develop this innovation on this particular date. In a research paper, you do not get any protection as such on the technology that has been disclosed. At best, you have copyright protection, probably, but copyright protection as such is not a very strong protection in sense. If you are going for technological protection, anyone can use that technology and use it to their benefit if you do not have a robust protection available to you. A provisional application, once it is converted to a complete specification, would protect the disclosed technology for 20 years once you get a patent on it. No or minimal monetary benefits that are received by the publisher author. You may get something based on that research paper. Maybe you might get some monetary benefits, but the many monetary benefits that you may get in a patented technology would be way more than what you could get from a research paper, because again, the protection is weak. Whenever you go for licensing of any technology, the licensees would always be interested in getting a protected technology rather than one which is there in the public domain for anyone to use. So in that sense, a patent would help you get better monetary benefits as compared to a research paper. I have already discussed that the research paper, as well as a provisional application or a patent application for that matter, aid in technological development. You are disclosing it to the public. Anyone can work on that particular technology and develop a further better technology or maybe a different technology based on whatever you have disclosed to the public. Right. So coming to what are the preparation steps for before you go ahead and file a provisional specification. So first of all, you need to understand what does your innovation relate to. What are the key features or key steps that are there? Maybe you may have done some research on what is already existing and what developments you have carried out on top of all that knowledge that was already existing. So maybe you might have suggested some new features or some new steps that that you are proposing for a particular innovation. So you need to, in a way, list those out as to what are those key features which you want protection on. You need to decide what is the field of invention. So this is more like a procedural aspect, because you need to disclose this field of invention whenever you are going ahead with a provisional specification followed by a complete specification and towards grant of patent. This is important because what the patent office does is they'll evaluate your innovation based on the field of invention. So if it relates to the field of maybe vehicle security systems, so then they'll do the search only in the field of vehicle security systems and not relating to some other field. So this is in a way to limit the scope of search or examination that needs to be carried out by the authorities who would be examining your patent application. So And you also need to decide the title. So title in a way gives a brief view of what you intend to do in your innovation, what you are proposing in your innovation. And that's the reason a title is a very important aspect, because again, this is also used in many searches by the patent offices, so as to get an idea as to what is the innovative aspect. Sometimes people do mention about the innovative aspect also in the title. So these are the basic steps that you need to carry out when you are going ahead with the filing or drafting of a provisional specification. Then you need to conduct a prior art search based on whatever features or key features that you have identified in the step before that. So as I said, these key features would be the ones which you consider as the unique aspects of your innovation. So what you want to do with a prior art search is to find out if someone else has done a similar type of research, or maybe if a similar research was carried out, what was the solution that they were proposing, and whether your solution is different from what was proposed earlier. So the prior art search helps you find out what is the existing technology, and maybe if they are different from you, and how you are different from them, how you have in a way been technically advanced over what is already there. So you can carry out a prior art search on Google Patents. This is a free database that is available. There is a specific website you can search for Google Patents, and maybe put in some keywords uh, relating to your innovation, and find out if there are any existing patents or publications there which relate to the same sort of technology, or maybe similar technology as yours. And you can evaluate those uh, uh, prior arts that you find out, and maybe use it for developing your innovation further if required, or maybe use it as use it to find out what are the technological advancements that you have carried out. That would help you in drafting of the provisional application as well as the complete specification whenever you do it. There is another patent database which is free, which is WIPO Patent Scope. So you can search for WIPO Patent Scope in Google, and you'll get the website. You can search for, so WIPO is the international office in International Patent Office for you can file PCT applications, international applications under WIPO. So they also maintain a database of whatever innovations are happening throughout the world. Whosoever files with them, they have a database of those innovations, and it is like a repository of innovations happening throughout the world, and thus is a very, I would say, elaborate database in that sense. Similar to Google Patents, it has many. Uh, it is a very big repository, so it would be very helpful if you do a search on at least these two databases. Then there is a website of Indian Patent Office. Again, you can search for Indian published patent applications and patents on this particular website. You can search in the title, you can search in the uh, complete specification or the detailed description of the invention to find out uh, whether whatever you have as your innovative aspects, whether similar things have been disclosed prior to you. Then there are non-patent databases. You could again go for a usual Google search. Sometimes what happens is your innovation might have been disclosed in a product somewhere in the world, and if you search on Google, something like that may emerge as a prior art. So if it is there on Google, most probably your innovation is already there in public domain. So that also helps you in a way understand what is the existing technology, what is there already in the market, and if you need to develop further develop your technology, what needs to be changed or from the existing technology. So this is what a prior art search helps you do. Uh, Also, in case you have an innovation which can be described with the help of drawings, please prepare a very basic drawing. These drawings could be hand drawn as well for the purpose of a provisional specification. You need not have a very scaled sort of drawing, or maybe an AutoCAD drawing, though it is advisable to always file clear drawings. But in case you are short of time or maybe short of resources, then you can also file hand-drawn drawings, but which should clearly depict what your innovation is. So you could, maybe if you have made a circuit diagram of a radio receiver, you could in a way make that with the by your hand and submit it, or maybe make a block diagram of what are the key elements of the radio receiver that you are proposing, and file it with the patent office along with your provisional application. Why drawings are necessary? Because it helps you explain the innovation in a better manner. Please consider that the examiners and controllers who are there in the patent office may not be as conversant with the technology as you are, because you have been working on a particular technology day in and day out, and you know basics of that particular technology. But these examiners and controllers may have to examine different technologies, different technological areas. They may not be working specifically in that particular area. So you need to provide them with as many aids as possible so that they can understand the innovation in a better manner. So that's the reason drawings are generally necessary. In case you can file drawings, it's always advisable to file drawings. Right. So now let us see what are the important parts of a provisional patent application, and uh, these parts are which you should include in your provisional, essentially include in your provisional patent application. You could miss out on other non-relevant or non-essential parts, but these portions should at least be there, because there has to be a specific format in which you present your innovation to the patent office. So first, as I said, the most important thing is the title of the innovation. It indicates what the invention relates to. And you have to limit it to 15 words. So you need not go into long statements about what the innovation does. You could briefly mention about what the innovation is. So as I said, maybe if you have developed a new radio communication device, you could mention that it the title would be something like a radio communication device. That's it. Or maybe if there are some specific features that you are uh, that you have introduced, maybe a lightweight radio communication device, you could mention a lightweight radio communication device. So something like that. So in a way, you are just giving the reader a brief introduction of what your innovation relates to. And please remember that you need not go beyond 15 words for the title. Then comes the field of invention. Here, you define what is the technological area to which your invention relates to. So I talked about the field of invention earlier as well. And as I said, it is useful in the examination process. Whenever this happens in the complete specification stage, whenever you file it, whenever the examination happens, it is basically for the patent office, to aid the patent office to understand what technological area of innovation uh, uh, your technological research relates to. So for example, as I said, I've taken few examples here. I'm saying that in case your innovation relates to a communication device, you could say that the invention relates to a communication device for wireless network. So it could be as broad as that. So this gives the patent office a brief idea regarding what is the invention relating to. So whenever he has to do a search, he would always do it in a communication device, not in any electrical device or any electronics device for that matter. So this in a way helps him limit his search to a particular field. Then I've also taken an example of chemical invention. Maybe if it relates to a chemical product. So you could say that, suppose it relates to a composition for hair color. So then you can say that the invention relates to a composition for hair color. So this is very brief about the technological area to which the innovation relates to. Then comes the most important part of a provisional patent application, which is the background of the invention. So background of the invention, as I had already discussed, you would be finding out, you will be doing a prior art search. It is where it is in the background section where that prior art search comes handy. You would have found out different prior arts or maybe existing technology that is already there. So here in the background section, you will disclose what is the existing state of the art or this existing knowledge that is existing in this particular field. So like in hair colors, what is existing in the compositions that are already there in the market, or if there are radio receivers, what is already there in the existing radio receivers. So you can disclose that here in the background section and explain to the controller or the examiner as to what is there already known in the field. Then you point out what are the problems that existed in that existing state of the art. So in a way, you are pointing out that these were the problems that were faced in whatever was existing, and this is how I have developed a solution for those problems. So in a way, you are pointing out towards there is a need for your innovation, and then you will go ahead and explain how you have solved that particular problem. So I hope you have understood as to what is the requirement of the background of this section of the invention. It only points out to what is the existing technology, what are the problems that are existing in that particular technology that is there, and how there is a need felt for your innovation. What are the drawbacks in that particular technology? Please remember that you are not required to disclose about your innovation in the background of the invention. You only talk about what is already there existing in the state of the art, and you are not going to disclose your innovation here. So that would come in the next section. So as I said, I've taken an example. So maybe there was a need for a hair color that would stay for long periods. So the existing hair colors do not stay on for maybe more than 15 days or 20 days. So you have developed a composition that stays on for maybe 2 months or 3 months. So what you have done is you have brought out a need for a hair color that would stay for a long period, and this is a need existing in the existing technology. Or maybe there might be a need for a communication device that ensures secure communication. So probably you have made a communication device that enables secure communication. So here you are bringing out the need that the existing state of the art did not have, or maybe did not have a robust secure communication system. So now what you are proposing is a robust communication system. So this is how you are bringing out the need for your innovation. Then comes the brief description of drawings. Obviously, this would be there only if you have drawings included in your provisional specification. So what this section relates to is you briefly describe that there are drawings in the innovation in the provisional specification and what each drawing relates to. So here I've taken some examples, like figure 1 depicts a block diagram of the communication device. So in case your innovation, your provisional specification relates to the communication device example that I had taken. So figure 1 may be depicting a block diagram of the communication device, or figure 2 may be depicting a flow chart of the method that is carried out in that particular communication device for enabling secure communication. So this is how you include these different drawings. I just wanted to say that you need not limit your drawings to whatever I have disclosed, that there has to be a block diagram or there has to be a flow chart. It totally depends on you as to how you want to disclose your innovation, how you want to explain your innovation. The only thing is you need to give a brief description of what each drawing relates to, so as to give the reader an idea and maybe refer back in case he is seeing the figures, can refer back to the brief description on drawing and see as to what this drawing is illustrating or depicting. Again, in case of a hair color, maybe you may have a flow chart for a method for making the hair color. So maybe you could have defined the steps that are carried out. So you could have a flow chart for that. So figure 1 may be relating to that, or figure 2 may be depicting an apparatus that you use for making that hair color. So in a similar manner, you could describe as many drawings as you have included and just give a brief description. You need not go into the exact details. Just give a brief description of what each figure is relating to. Then comes the most important aspect of a provisional specification, which is the description of invention. So here what you do is, here you'll define your invention very broadly, or maybe you'll describe your invention. The reason I've mentioned broadly, I'll just take it up in a short while. But this is where your innovation would come. So if you remember, I said that you don't have to disclose anything about your innovation in the background section. You have to disclose your innovation in the description of invention, because here the unique aspects of your research or innovation would start. So the purpose of a provisional patent application, as I said, is to, in a way, provisionally protect your innovation. So what may have happened is, you may have done research, but you may not have done it extensively, so as to have the uh, immediate or the exact details of each and every component of, again, taking the example of the radio receiver. Maybe you may not have thought of how each component of, or each module of that radio communication device would function, or what would be the components of that. So it's basically an idea that you have as of now. So just to protect it in your name, you file a provisional patent application, you with uh, whatever details are available to you. So as of now, you have just thought that I want to make a secure communication based radio communication device, and you have a very vague idea about, okay, these are the modules that I'll keep. So what you can file is a provisional patent application defining your invention, defining what you intend to do through this innovation in a very broad manner. So you need not go into the exact details of each module or each component, and that could be done at a later stage when you file a complete specification after filing the provisional patent specification. And for that, you get a period of 12 months to develop your innovation and maybe come up with more details. So so in a way, what you'll do is you'll very broadly define your invention without disclosing specific details. As I said, if you have those details, you please go ahead and disclose it. But in case you don't have those specific details, don't be in a way disturbed by that particular fact that that you don't have those specific details, and there's no limitation as such that you have to, in a way, disclose your innovation in the specific manner. You could do it at the time of the complete specification, as I said. Then you describe the features in case your innovation relates to a product, or in case your innovation relates to a method. You could describe the unique steps that you have thought of, or whatever is the part of your research. Then you describe how the innovation or invention achieves the intended goal. So if you remember, in the background section, we had talked about that there are drawbacks in the existing state of the art. So there was a need felt for your innovation. So how your innovation is tackling with those drawbacks, you could define here. You could say that these were the drawbacks that were felt in the prior art, and this is how my innovation is solving that particular problem, and that is how it is achieving the intended goal. Again, in the description, when you are describing your innovation, you need to refer to the figures. The figures you would help you describe your innovation in a better manner. Obviously, you would refer to all these figures and point out the different features, or maybe the different steps, so that for the reader it is very easy to, in a way, refer back to the drawings, read your description, and then understand the innovation. Right. So these are the basic steps that you need to carry out. These are the basic, I would say, pointers that you need to take care of. One is the title of the invention. The other one is the field of the invention. Then comes the background of the invention, which is, you talk about the background art or the existing technology. Then you define the brief description of drawings. In case there are drawings, you would define what those drawings relate to, and then move ahead to description of invention, where you describe your innovative aspects of your research and show as to how your innovation is achieving the intended goal and maybe solving the problems that were there existing in the prior arts or the background technology. So this is
Yes.
what all I had to share. Yeah.
Yeah, Nishant, we have a question from Mr. Amit. He's
Okay.
asking what happens when someone else files for a patent complete specification of the same invention before the person who has filed a provisional specification too.
So if someone has filed a patent application, a complete specification, or even a patent provisional application before you for the same innovation, obviously he has the prior right on that innovation. So you have to be very careful of not disclosing your research work to anyone before you file a provisional patent application, and that's the reason for it. You need to get that protection as soon as possible by filing a provisional specification. So India is a first to file system. So whosoever files the innovation first would get the protection. And I think across the world, now the system has changed to first to file. So this is what you would face everywhere in case someone already has filed for a patent for an innovation, which is similar to your research work. Then unfortunately, you may not get rights on your innovation. I hope that answers your question. Right. All right. So what I intended to do was maybe just since this was very a brief sort of introduction to a provisional patent application, I intend to show to you what are the how a provisional patent application compares to a complete specification. So I have an example with me, which I'll just take you through very briefly. This is one of the provisional application and a complete specification that I drafted quite some time back, and maybe I'll just like to share that with you, so that you get a brief idea about how do the two compare, and what how much detail you could give in each of the specifications. Before that, I have captured this entire thing already in a YouTube channel that I created for again for imparting knowledge on IP. So this is my channel. There are different videos already there for again the same thing as drafting a provisional specification. So please feel free to refer to that in case you need more information on these aspects. Okay, so this is about the life cycle of patent. I think if we have time, we'll just discuss it. Otherwise, I won't take it up. So very briefly, this is an innovation which is related to the reflectors that are put on. I hope you can see the screen, right? There's a PDF document that I'm showing.
Yes, it is visible. Yeah.
Yeah. So what the innovation relates to is this person had made the reflectors that you see on road for reflecting light at the time of at night time specifically, so as to guide the riders that are there on the road. So as you see, the title talks about a visual guidance system for pathway safety. So I've just kept it as broad as possible, so that you could include, you need not be very specific. If you want to be specific, you could be that specific also. But this is a drafting art that I think usually lawyers do. So as academicians, I don't expect you to be using legal acumen as such. So you can put in specific titles also. So maybe you could put a reflector system for pathway safety or for roads or something like that. So what this person had developed was, I'll just share these figures of the device. So this is a type of reflector that he had developed and he intended to keep on to install on roads. And this has an LED system which glows. And what happens is there is a lens mechanism somewhere here which is installed, and it helps spread the LED light to a greater distance so as to in a way provide more visibility to any riders, specifically in foggy conditions, or maybe when there is the light is very dim as such. Apart from that, what he felt there was a need he felt in the existing reflector systems was that due to dirt on the road, these reflector systems, the dirt gets accumulated on these reflector systems, and thus, as a result, the light that comes out of it, or the reflection is very poor. So the riders are not able to see these reflectors. So what he developed was a self maintenance mechanism, he said, which in a way clears, it has a sort of air pump mechanism, which in a way clears the dirt that is deposited on the any of the reflecting sides. So this is what is, these are the drawings of the complete specification. So if you see, these are very detailed drawings that are there. There is a specific angle of the lens mechanism, and all edges have a different shape, and this is all that is described in the complete specification. So when we were developing the provisional specification, we didn't have as many details as I've shown to you. So he was developing the assembly, the lens assembly at that point of time. So in that respect, what we did was just defined the invention in the broadest possible manner as such. So if you see, again, I've referred to the same, this is the title, this is the field of invention. If you would read through it, very broadly, I've mentioned about that it relates to a field of pathway safety, and then very specifically, it relates to a visual guidance system. And then I've talked about the background of the invention, where I've talked about the existing reflectors that are there on the road, and what are the problems that are faced when using those particular reflectors. So here I've pointed out the problems that are there, and that they get dirty and they're not effective in foggy conditions. Then I pointed out what is the need for my innovation. So the need is that there has to be a effective visual guidance for the drivers in foggy conditions. Then we go on to the brief description of drawing. So now you would see I've only used a single figure, because that is what was available at that point of time. It was, the innovation was only in the concept stage at that point of time. We had not thought of how the reflector would look like, what would be the components inside it. So we only used a single figure, which said that we only broadly describe the visual guidance system as such. So this is the basic figure of the visual guidance system. Then we go into the detailed description. Here I've described using that particular figure. If you see, I've referred to the figure, and I've described that this is the visual guidance system, and it has different modules, like the module 105, and then there is a self maintenance mechanism module inside that particular housing of the reflector. So again, these are very broadly defined. I've just mentioned that these are the intended features of the self-maintenance mechanism. I haven't shared how these features would be enabled. So it's a very broad description, because that is what was available at that point of time. So again, the module has LEDs and reflectors which throw light onto the road. Now again, I have not defined how the reflectors are configured, what is the way in which the LEDs would be configured relative to the reflectors, and how that would throw light on the road. So now this is very broadly, I have described the innovation. You could make out it is only a 6-page provisional specification. And this is the basic drawing. So this is the module that I've described. And this is what I've shown is that this is the area of elimination that would happen using my innovation. This is how it is guiding the rider on the road. by providing more area of elimination without any specific details. Now, coming to the complete specification, again, complete specification also has similar fields as similar parts as I've disclosed for the provisional specification. Again, a slightly bigger background of the the existing technology. Here I've referred to some existing patents, and because once he gave us with all the details, we conducted a further prior art search, found out what are the existing solutions based on whatever details he has provided, and then after an extensive search, we could find out these 2-3 patents which were there, and then we described it and explained what is the need, what are the drawbacks in all these reflector systems, and what is the need for our innovation. So now quickly I'll move on to the figures. So if you now notice, there are maybe close to 10-11 figures which are there. So these are all these figures which I have shown to you earlier. This is how the device is configured. This is the area of elimination, and we have explained everything in detail now, because we had the details once we were ready to file the complete specification. And this is how I have described, referring to each of the figures, what are the different modules in there, what are the different aspects, what are the different features, how those are interrelated to each other, how those are connected, and how these features work together so as to achieve the intended purpose of the innovation, which is to throw light for a greater area of elimination onto the road. And then again, there is the self maintenance mechanism, which I've described in detail in respect of figure 4, if I remember correctly. So these are all, again, yeah. So here, with respect to figure 4, I've explained the self-maintenance mechanism. So if you would recall, in the provisional specification, I had not given any details of what are the different parts, what are the different components. But here I am disclosing everything. I'm disclosing how these parts are connected to each other and how they are functioning in tandem with each other so as to achieve this intended goal. So complete specification is, again, a different aspect of drafting patent specification. We are not going into that as of now, but just wanted to show to you how different a provisional specification is from a complete specification. You could go very broad in a provisional specification in case you have a concept and not developed concept, and maybe within 12 months, if you have all those details, you could go ahead and file a complete specification. So now the protection that you have gained would be from the date of filing of the provisional specification, not from the date of the complete specification as such. So this is what benefit you get in that by filing a provisional specification. So I think this is all I had regarding drafting of provisional specifications. In case I know it was a very rush through session. Obviously, I can't go into exact details in 1 hour time, but I tried to convey as much detail as possible. Maybe if you have any particular questions, you could direct them to me, and I'll be happy to answer this.
So I have a question, if I'm permitted to ask.
Right, yeah, please.
So there's I don't know, being a professor and being a law student of IPR for a very long time, I've always had this in my head that, that patents can only be drafted and filed by people who have science background. I think I have the major concern with this. I mean, what about with commerce, and then people like me who have just done commerce without maths also, which is an underrated position in life. But is it a myth that only science background people or attorneys could be patent attorneys, or anybody could be a patent attorney or could file for patents?
As insofar as filing of patents is concerned, unfortunately, in the Patents Act, the requirement is you could file it either, if you are the applicant, you could file it directly. If you suppose you have made a patent, you have made an innovation, you could file it as the applicant or as the inventor. So there is no restriction on you as such. You may have thought of being a commerce background person, you could have thought of some technological aspect, and you could protect it by drafting your own patent application. But if you are getting it done through a professional patent agent, that patent agent has only to be a science graduate. That's the limitation under the Act. There have been challenges to this particular provision, I think, before the Madras High Court also. But the Madras High Court finally held that there is a specific requirement for in the Act that this patent application could only be filed by a patent agent who has to be a science graduate. So unfortunately, that position still stands. As a patent attorney, if you have to practice, you could be commerce background graduate. It doesn't matter as such. The courts don't ask for a science degree as such whenever you practice before courts. Or in fact, even the Patents Act allows lawyers to appear in hearings, even in technical hearings. So I had my colleagues who were commerce or arts graduates and who had done law, but still they appeared for patent hearings for technical matters. So as such, it only depends on your capabilities. As a patent attorney, you could argue before the court, you could argue before the patent office, being a lawyer. But for filing patent applications, you cannot, if you are not a patent agent, unfortunately, you won't be able to file a patent application for your client as such. I hope that answers your question.
Yes, it does. Thank you so much.
Yeah, Nishant, we have a question from our YouTube channel. When a provisional specification is filed and followed up with a complete specification filed as an international application, how is the priority date calculated?
So the priority date is the date of your provisional application. Within 12 months of it, you can file a complete specification either in India. You could also file an international application. So if you are taking priority of your provisional application, so the purpose, as I said, of the provisional application is to get the priority date. So once you have filed it, you can derive any type of complete specification out of it. You can file it as a Paris Convention application in some other country, or you could file it as a PCT international application deriving the priority of the provisional application, or you could file a complete specification in India itself as an ordinary application. So the priority date would be the first application where you have disclosed your innovation. So that is your provisional application. I hope that answers the question.
Anyone else having any kind of questions?
So I think there is one question from Dr. Pravesh. What kind of patents can be done in education? It's very difficult to go for patents in humanities, social sciences, and education. So this is a very, I think I have dealt with people who have been innovating in the education field as such. Again, you cannot in a way innovate or seek protection on a method of teaching per se. But what you can do is claim an innovative aspect on how you are aiding that innovation. So maybe you may have developed an AR VR system. So there are people who are getting all these AR VR systems protected also. And these are aiding in innovation. So maybe you might have developed a new sort of system which helps in education field. Probably that could also be protected. But yeah, there are limitations. As I said, you cannot protect a method of teaching. So maybe if you say that, okay, this is the way I teach and I'll try and patent it, that's not allowable. So this is where, if you recall, I talked about the industrial applicability. So these are somewhat like an abstract thing which anyone should be allowed to do. No one should claim monopoly over it. So that's the reason these things are not protected as such. Right. I think there are no further questions. Sorry. Yeah.
So thank you a lot, sir. You have. Okay. Thank you so much, sir, for joining us. And I hope
Pleasure.
you have cleared all the doubts and made this topic very clear for everyone. And you have given us insights about such a complex matter. Thank you so much, sir.
Pleasure. Thank you very much. Thank you, IPTSE team. Thank you, GOENKA University.
Thank you, sir.
Okay, bye-bye. I'll take your leave. Bye-bye. Thank you.
Thank you so
Thank you
much.
so much. Thanks.
Bye-bye.
So before we end our webinar, we would be sharing the details about our IPTSE 5th edition. And Utkarsh, can you just take us
Sure.
tour?
Okay, so hi everyone. This is Kurt from Team IPTSE. For now, the first thing we will be showing you is a glimpse of our 4th edition awards. And that was a very successful event, which was held at the FICCI, that is in Tansin Marg in Delhi. I'm just showing you a glimpse. Is my screen visible to all? Hello? Is it visible?
We can't see the video, but the screen is visible. Yeah, now it's visible.
Okay. Sure.
India is on the cusp of a big IP revolution in both adjudication and in administration. You are the people who are going to enable this country in this knowledge economy. The way you're contributing to Atmanirbharta of the country, it's an unparalleled, I would say, initiative from your side.
I would commend the job of role of IPTSC, wherein you are reaching out to schools. When they grow up, they take this subject of IP very consciously, and they don't take it as a hindrance.
So when we're talking of innovation, we're talking about IP coming together. We should really look at the export potential of this market.
That's it.
Thank you, Utkarsh. So now I would like to take you through the presentation on IPTSE's 5th edition. Can you share the file, Utkarsh? So, welcome everyone. We are going to discuss IPTSE's 5th edition and what is in store for all of you. Next slide, Utkarsh. IPTSE was launched in July 2018. It is an initiative of Epithicon. It is first of its kind nationwide IP Olympiad. We have been awarded by World Intellectual Property Forum as an appreciation towards our contribution in IP awareness. We have successfully culminated 4 editions, and the 5th edition has been already launched on 1st of September 2022. Next, Utkarsh. This is our honorary advisor panel. So there are lots of great personalities from the industries. Next. These are the corporates and the government bodies which have supported our various past editions. Our industry partner is Ericsson, knowledge partner is Creative First. The government bodies which have supported us are like FICCI, MSME, AICT, Ministry of Science and Technology, NRDC, Inspire, and many others. The achievements of our 4th edition are as follow. We have created a unique dashboard with the excess of learning material for each exam aspirant. We have organized 50 plus webinars. We have facilitated 50 plus awardees with the awards, trophies, and certificates. We have also offered internship to the winners basis their selection through interviews. And the launch of e-copyright handbook is made freely available to all our exam aspirants. So these are the government dignitaries who have marked their presence in our various editions as the chief guest and guest of honor. So Shri Suresh Prabhu was our chief guest for the 1st and 2nd edition. For the 3rd edition, it was Shri Anil Sahasrabuddhe. For 4th edition, it was Honorable Justice Pratibha M. Singh, High Court Judge, and Professor Unnat Pandit, who was Controller General of Patent Design and Trademarks. He was our guest of honor. Next. So these are the details of our 5th edition. In this edition, we have been given support by AICT, NRDC, PSCST, Ministry of Electronics and Information Technology, and FICCI. Our industry partner is Ericsson and our knowledge partner is Creative First. So the unique features of our 5th edition are, we have created a learning management system which is going to track the reading performance of the students or the participants. So there will be a dashboard where there will be the study material and students can check the participants can check how much they have studied. So the main aim is not just to register the participants and they should appear for the exam, but also they should have a knowledge about IP. And we have also created an app for the same. Provisions of e-learning material is available through the unique dashboard. We have the question is very domain specific. So a student from a technical background, from a BTech background will be having different question as compared to one with the architectural background. So there are free handbook on copyright case studies which are given to all the participants. Different time slots are available for the mock test and final examination. So students, participants also get an opportunity for giving these mock tests so that they're able to analyze how much they have prepared and how much is left for them to prepare. The process and timeline. Our registrations have started from 1st of September and they're going to end on 30th of October. Earlier it was 15th of October, but now we have extended till 30th of October. Mock test dates are from 15th of November to 20th of November. Our final examination is going to be held on 23rd of November to 30th of November. There are different time slots available as we are not just including the college, university students and the school students, but working professionals, faculty, and startups are also included. So we have given the ease of time and they can give at the comfort of the time. The award ceremony is yet to be announced. So the eligibility criteria, so as I have told you that we want to spread the awareness on IP. So we are not just concentrating on the college students and schools, but we are also focusing on the faculty, working professionals, and the startups. So the fees for the college students is $499 and 999. So we have two packs. One is the basic pack, which is of 499 rupees, and the advanced material, the premium version is of 999 rupees. It is actual price is 1510, but we are providing a special discount for your university, and we are giving it at a price of 999 rupees. For faculty, we have kept the same prices, 499 for basic pack, and for the premium pack, it is 999. Next. So the benefits and reward of participating in this Olympiad, from the point of view of a student, the students will gain knowledge and awareness on IP. Certificates and prizes, prize money will be given to the top winners. Internship opportunities for the top performers basis the selection process. The students will be able to know how to reap the monetary benefits of their creations and innovation. It will also give a competitive advantage in their career shaping. For next slide. So the award categories for the 5th edition are the university students. We have kept three ranks: AIR 1, AIR 2, and AIR 3. We are giving them a prize money of 50,000 rupees for AIR 1. For AIR 2, it is 25,000, and for AIR 3, it is 10,000. For faculty, we have also kept a prize money of 50,000 rupees. So, we have kept an award for the best university also. So there is AIR 1, AIR 2, AIR 3. I hope this year your university scores a rank of AIR 1. Then there are domain specific awards also, and awards for IP recognition. Next. So this is the exam guidelines for the for this edition. So there will be 60 minutes for university students, and there are going to be 60 questions for faculty. It will be 45 minutes. There is no negative marking. The candidate scoring 40% or above will receive a pass certificate. The rank holders are chosen on the basis of accuracy of their answers and the total time taken to complete the exam. So suppose two participants are scoring the same score, so the lesser amount of time taken by a participant will be a deciding factor for this winner. Next, Utkarsh. Thank you so much. You all have been very patient for the presentation. And now Utkarsh will be taking you through the registration process.
Yes, sure, Nudit. Okay, is it visible? So first we are starting with the individual registration process. That is when a student goes to the registration portal, that is the e-learning platform, and registers. IPTC has a very simple approach, that is just the phone number and the OTP process. So there's no need of remembering the passwords and email IDs, etc. Enter the phone number, you will receive an OTP. If you're a first-time user, you will be directly landed to the sign-up page where you have to fill the details. If you have already registered, you will directly go to the dashboard where you have the access to the materials if you have already paid the amount. Yeah. So just fill in the details, that is the name, email, your profession, whether you're a student, whether you're a faculty, whether you're a working professional or a startup. Then the organization for the students, organization is the college. For the faculty, it's the college. For the working professional, is the company they're working for. Then the state, and yeah, this is the part in which you have to select a domain. We have multiple domains like engineering and tech, India, hospitality industry. You can see all of them here: design and architecture, law students with and without IP, and then mass communication and multimedia also. Sign up, enter the OTP, and this is the dashboard where you will get all the details about the webinar, like the one you are attending right now. This is the two packs we are offering. One is the basic pack, as I already told you, and one is the premium pack. We have multiple payment options. That is a very favorite UPI, then the cards, net banking, and everything. Okay. So now we have the bulk registration process if the university wishes to register the students on their behalf. Again, we have to go to e-learning platform. On the top right, you can see there's a bulk registration button.
Voice
Sorry?
is not clear. Utkarsh, your voice is not clear. They're not able to understand.
My voice is not clear.
Yeah, because you have turned on the volume of the video. So
Oh,
there's
sorry. Is it better now?
Yeah.
Okay. So now we are on the bulk registration process. This is where the university wishes to register the student. You have to just go and enter the university email. You will receive the email on the you receive the OTP on the email. I'm sorry. Then just select who you are, whether you are a school student, university student, organization, or a startup. Once that is done, enter the name, the details of the spokesperson. That is the name, phone number, organization's name, and the organization's email. After that, you have to. Okay. So after that, you have to upload the data of the student. There's a sample data file. This is how it will look, and this is how the data should be uploaded. Once you upload data, it will show you the number of entries they have. Here is the Excel file got 7 entries. Okay, this is the payment summary. It will show you the number of records, your total payment, and whether you want the invoice, a bulk invoice in the name of university, or you want an individual invoice in the name of students. And then this is only for the basic pack. If the person goes through the bulk method, if they want to upgrade to the premium, they can through the dashboard. Again, the same payment procedure. There's UPI, there's card, there's net banking, and the registration will be done. Thank you.
Thank you, Utkarsh. Any feedback from Azim sir?
Anrit, I guess there's some questions that you can see in the chat box.
Yeah. Actually, no, you can't register for free, sorry. We have a fees of 499 rupees and 999. That is also at a discounted price. Because you will be getting a lot of things like study material and webinars to attend. You have doubt clearing sessions. Everything is there. So that is the reason it is not free. See free for students. Can you just share the link, because I don't think so there is any such link saying that it is free for students. Can you share the link, please?
Utkarsh, you may type on the registration link on the chat box so that.
Sure.
Teachers.
Maybe there's some confusion about the link for the registration of the 5th edition of IPTSE and the registration for the webinar. I think they mixed it up. Maybe
Yeah.
that's. I think that
The
could be a
registration
reason.
for the webinars is free, everyone.
Yes,
But the
registration for the
registration for the
webinar was
5th
free.
edition of IPTSE, there's a fee.
Yes.
Any other questions from anyone?
Any other feedback or questions?
Okay. Anything you would like to share, Azim sir? A feedback for us or something?
I think, ma'am, we're good to go and call this off. If at all any students will have an issue, I'll start posting their queries to Anurit
Yeah.
ma'am, and then we can sort it out from there as well.
Yeah, because I think many students will have queries. Actually, when the webinar was on, there were around 58 participants. But
Yes,
when the
and
IPT presentation started, they came down to 33.
maybe we can schedule
So
one
those
more.
20,
Yeah,
those
maybe we could
23
have
who
another
left
one.
will have queries.
Maybe we can have another query session with Anurit ma'am per se, and then if any students have an issue or with Utkarsh, if they have any facing any technical glitches, because we're not that tech savvy at all. So if there is any, I'll shoot it to Anurit ma'am, and then we can schedule another small webinar for like half an hour, 40 minutes to have a clear idea about it.
Sure, sure.
Okay, ma'am.
Ma'am, you want to add something?
Ma'am, it was a great session. I think possibly we can all have a physical session. Saurabh sir, thank you so much for your time. And Anurit ma'am, this has been back and forth with both of us. And I hope we've tried to do a little this time. And I hope next time you can physically come down so we can all see each other and possibly have a bigger crowd on campus and then fulfill it, ma'am. Thank you, Saurabh sir.
Thank you so much. And absolutely, definitely will plan maybe a physical offline session in the coming time. That's for sure.
Yeah.
Thank
Perfect,
you.
sir. Perfect, sir. Thank you. Thank you, Utkar. Thank you, ma'am. Thank you, Anurit ma'am. Thank you.
Thank you, everyone.
Thank you. Thank you all. Thank you so much.
Thank you, sir. Thank you so much. Thank you. Thank you.